let me explain my vote. The acts of each branch of government must not be controlled by or subjected to the influence of either branch because, Mr. President, such is the essence of separation of powers. My vote relative to Resolution 312 would have been to abstain, as mentioned earlier. Our republic is a sovereign and democratic state which is founded on the will of the people, which in turn endows our government with its vast and awesome powers. Maintaining their balance is the time-honored principle of separation of powers, which is enshrined in our 1987 Constitution, Mr. President. Now this principle was put to test, or is being put to test once again, as the country grapples with the recent developments in foreign and national security policies relative to the Visiting Forces Agreement, or the BFA. We are not, Mr. President, yesterday or today, we are not voting here for the retention or abrogation of the BFA. We are not voting here to determine whether the BFA is beneficial or detrimental to the country. What is at issue here is the separation of powers among three co-equal branches of government to maintain the balance required by the Constitution. Does the President have the power to abrogate a treaty under the 1987 Constitution? I say yes, Mr. President, considering the President's role as the chief architect of our nation's foreign policy. This includes the decision to terminate the existing Visiting Forces Agreement, a political process with regional and international consequences. This goes into the very essence of executive power, which is in Article 7, Section 1 of the 1987 Constitution, and is vested in the sole person of the President of the Philippines. The Constitution, Mr. President, is enduring, and upon its inception is intended to exist for ages. It governs the rights and obligations of the people, not only at this time or at the time of the framing, but also the far-reaching future. Its permanence protects the stability of fundamental rights and liberty. To quote President George Washington in his farewell address on 19 September 1796, and I quote, "The Constitution which any time exists, till changed by an explicit and authentic act of the whole people, is sacredly obligatory to all." It is without question, Mr. President, that by constitutional fiat and by intrinsic nature of his office, the head of state is the sole organ and authority in external affairs of the country, as the Supreme Court declared in Bayan versus Zamora, GR 138570, and Pimentel Jr. versus Executive Secretary. The U.S. case of Myers versus United States in 1926, 2722 U.S. 52, is instructive, as it tells us that Congress' power to remove or the right to participate in the exercise of a power given to the executive would infringe on the constitutional principle of separation of powers. The deference we give to the executive department is dictated by the principle of separation of powers. This principle is one of the cornerstones of our democratic government. It cannot be eroded without endangering the government, as stated by the Philippine Supreme Court in Secretary of Justice versus Lancion, GR 139465. Although the unilateral withdrawal from a treaty by the President is an apparent vacuum in the field of Philippine law, this has been done before in other jurisdictions. In a long line of cases, the United States dealt with the question of unilateral withdrawal in Goldwater versus Carter, 444 U.S. 996, on President Carter's termination of the Mutual Defense Treaty with Taiwan. In the case of Beacon Products versus Reagan, 814 Federal Reports 2D on Reagan's unilateral termination of the Treaty of Friendship with Nicaragua, and Kucinich versus Bush, 236 Federal Supplement 2D1 on the U.S. withdrawal from the 1972 Anti-Ballistics Missile Treaty. All these three cases ruled that in the light of the absence of any constitutional provision governing the termination of a treaty and the fact that the different termination procedures may be appropriate for different treaties, the instant case, among others, must solely be controlled by political standards, and therefore the challenge to the President's power vis-a-vis treaty termination raised a non-justiciable political question, Mr. President. Other prominent examples of unilateral withdrawal from treaties included the withdrawal of Indonesia from the United Nations in 1965, of Czechoslovakia, Hungary, Poland from UNESCO in the 1950s, of the Soviet Union and 8 Eastern European states from the World Health Organization in the same period. Even more recently, President Trump of the United States also withdrew from the Iran nuclear deal and the Paris Agreement on climate change. In sum, states have always operated in purview of their national interest and have withdrawn from international agreements without congressional interference. Can the Senate inquire, then, into the President's wisdom to abrogate a treaty? Mr. President, while I am of the opinion, collectively with the members of this chamber, that we should strengthen the powers of the Senate relative to foreign affairs, the reason why this is solely lodged with the President is by virtue of the Constitution and by reason of his office, that the President has access to the almost comprehensive and confidential diplomatic information and ultra-sensitive military intelligence data. What then is the Senate's role in treaty making? Section 21, Article 7, Section 25, Article 18 of the 1987 Constitution requires Senate concurrence to bind the state to such agreements. However, there is no similar provision requiring the same to abrogate a treaty. Our obligation lies not in the termination of treaties and international agreement, but in its creation. Requiring Senate concurrence in instances of abrogation is to create an obligation where no such judicial precedent or law exists. The constitutionally enumerated powers of Congress, Mr. President, circumscribe its authority to the exclusion of all. Expressum facit cessari tacitum. Mr. President, by interpretation or instruction, this may not be extended. To the members of this august body, I end this manifestation, albeit with sadness. Baka po sa mga darating na araw, wala nang tutulong tayo sa pag merong disaster, pero ganyan po siguro talaga ang tinatadhana ng ating saligang batas na dapat manaig ang desisyon ng Pangulo. To the members of this august body, I end my manifestation with a quote from George Washington as an allegory to our current predicament. And I quote, "It is important that the habits of thinking in a free country should inspire caution in those entrusted with its administration to confine themselves within their respective constitutional spheres, avoiding in the exercise of the power of one department to encroach upon another." Sana po ang yugtong ito ng kasaysayan na sa palagay ng iba ay mahirap sa kanila o mahirap sa hinaharap ay malagpasan natin sa tulong ng poong may kapal. Maraming salamat, Mr. President.
Motion to adopt. The minority leader is recognized. Senator Dillon.
Yes, Mr. President, the manifestation of the good gentleman from Cavite compels us to make likewise a manifestation in that regard. Mr. President,
Again, sorry, minority leader.
Mr. President,
Yes.
the issue of whether or not the Senate concurrence is needed in the withdrawal of a treaty is precisely pending before the Supreme Court today. It is an open legal question. The good gentleman cited jurisprudence in America wherein the Supreme Court ruled that this is a political question. In our case, in our Constitution, the Supreme Court cannot shirk from that duty to interpret the acts of the different departments of the government on the ground that it is a political question. It is our submission that this is an open question. Second,
In fairness to the minority floor leader, can we ask for our colleagues to refrain from conducting little discussions? Because, well, the good senator from Cavite was discussing, I almost stood up, but there are important matters that we're discussing here, and I would like, out of respect for, not only for our fellow members, but because it's a vital issue that we're discussing today, to focus on the issues, Mr. President. This is not a partisan issue, Mr. President. This is an issue that involves national sovereignty, it involves defense, it involves our territory, it could involve many things, and that's why
The
I'd
most
like to listen
important-
to the minority floor leader.
And
My
most
motion,
important of all, it involves the Senate.
yes, Your Honor.
All right, Minority Leader.
thank you very much, Mr. President. As we said, this issue, the Supreme Court of the United States refused to review acts of the executive branch on the ground that the concurrence of the Senate or of Congress in the withdrawal from a treaty is a political question. In our present system, the fact that it is a political question does not provide a justification for the Supreme Court to shirk from that duty and obligation to interpret the acts of the political arms of this government. As we earlier stated, there is a pending case in the Supreme Court involving the withdrawal from the Rome Statute. And let me point out, Mr. President, that in about 25 resolutions in the 17th Congress, this Senate has included in the concurrence in the ratification of the treaty a provision which says that the concurrence of the Senate shall be secured to make the withdrawal effective. If there is any sense of the Senate, that is so expressed in these 25 resolutions, and this has, in our view and our submission, Mr. President, has a legal binding, legal and binding on the political branches of the government, because the Senate is a partner of the President insofar as treaty making is concerned. So it is our submission, Mr. President, that the fact that the United States and another jurisdiction, the decision has been that that it was considered a political question is not relevant to our discussion. We strongly submit that in our case, the Supreme Court will have to rule on this, and that the sense of the Senate was manifested in 25 of the resolutions in the 17th Congress, wherein we agreed on a provision that any withdrawal from the treaty should have the Senate's concurrence. Thank you very much, Mr. President.
All right, Senator Gordon.
Mr. President, would the gentleman pardon me if I ask him to continue to stand, because I'd like to ask him a few questions, if I may. Yes. The gentleman is the minority floor leader, and he's, I suppose, stating...
Yes, that is completely in order, because
Yes, ma'am.
he has the floor, he stood up, and anybody can question anything that he has said.
Thank you, Mr. President.
Yes, Mr. President, willingly.
Mr. President, the gentleman of the minority floor leader stated that the Supreme Court has the duty, the responsibility. It cannot shirk from its responsibility. And so far, the prevailing view is that it is a political question.
That's a jurisprudence cited by the gentleman from Cavite insofar as courts outside of the Philippines are concerned, citing specifically the U.S. Supreme Court, where this U.S. Supreme Court refused to touch upon a ruling of the lower court on this issue of withdrawal because it is a political question.
That is correct, Mr. President. But even in that Supreme Court, there were positions made by Justice Powell. Justice Rehnquist said this is a political question. Justice Powell said it is not. even in the case of Sagisag versus Ochoa, Mr. President, he said, our Supreme Court said, it is not an absolute prerogative of the President not to include the Senate if it is going to abrogate an agreement. Would you agree with that, sir?
Yes, Mr. President. In fact, that is reflected in the sentiment of the Senate, with it included as among the conditions for the concurrence of the Senate in the ratification of the treaty, that any withdrawal from the treaty should have the concurrence of the Senate.
Now, Mr. President, let me just go for the purposes of the gallery as well, and I'll not play to the gallery. Mr. President, in the wisdom of all in 1935, as well as in today's Constitution, it says that any treaty must be ratified by 2/3. And the reason for that is that when you engage into a treaty, Mr. President, I'm willing to keep quiet so that they can continue their conversation, if I may. Now, Mr. President, thank you. I'm sorry. I mean, I'm very passionate about this thing because I think it involves our national sovereignty, our defense, our people who could go into harm's way, and we are in a situation where any move that we do could affect that, Mr. President. So, would you agree with me that the reason why they had 2/3 vote is so that the co-equal branch of government, the Senate, will be part of a collegiate group, so to speak, and that's stretching it a bit, na dapat papakinggan ang Senado at tayo lang, hindi lower house, ha? In the Constitution, tayo lang ang nilagay doon na Senado ang siyang magra-ratify ng agreement. And that is because of the issues aforestated. These are matters of national interest, national sovereignty, national defense, and national territory. Tama po ba yan?
Yes, sir. The traditionally recognized prerogative of the executive branch in the conduct of foreign policy is qualified by the participation of the Senate, and that participation is in the form of concurrence in the ratification of treaties and, Mr. President, in the confirmation of ambassadors of the Philippines to foreign countries.
Now, yesterday, Mr. President, we had agreement here in the position that the ultimate steersman of foreign policy is the President. But we submitted that it is not an absolute, because that's why you had your resolution 3 years ago that says all treaties must pass through, because that is the intention.
Yes.
That is the intention of the Constitution.
Yes, Mr. President. In fact, when this chamber did not act on that resolution, we had the individual concurrence contain that condition, and that was approved unanimously.
That's correct, Mr. President. Now, Mr. President, in the matter of the American case, Mr. President, there was that position by Justice Powell, as if concurring with the later position of Ochoa, or the case of Sagisag versus Ochoa, that says there must be, he didn't say this, but it comes to me as there must be an overt act by the Senate to protect its prerogatives, to continue to be part of the conversation. Meaning to say, the President cannot just terminate because you asked permission to have this agreement, you had the Senate agree with this position, but you just cannot terminate because the same issues taken up when you were approving the agreement is now the same issue that you will have, and perhaps some changes have already occurred. At that time, we had no threats from our neighbors. At that time, our territory was not being taken. At that time, our ships were not, our boats were not being rammed. And so, Mr. President, would you agree that therefore there is a position that the position of Justice Powell and the position of Ochoa would now be timely for the Senate to say, maybe if the President doesn't change its course, and quite frankly, I am kind of confused at the Panelo saying we have issued, and then later on, Secretary Lorenzana says, no, there is no issue, and then finally, there seems to be confusion. And having said that, it behooves the Senate of the Republic of the Philippines that we stand up and say, Ano ba talaga? Kung yan na talaga ang sinasabi ng Pangulo, we have the duty. The gentleman, the minority floor leader was saying, the Supreme Court cannot shirk from its responsibility. Yesterday, I extolled the President of the Senate for saying, we have a say in the conversation. There are 3 branches of government. Kailangan kukonsultahin nyo kami. And now, Mr. President, gumalaw na ganito without attacking the President, sharing what the President feels right now, the Senate must now do its duty as part of the co-equal branch of government to create what you might call a justiciable position. A justiciable situation, I'm sorry, not position, where if we keep quiet, it remains a political question. Would you agree with that, sir?
Yes, sir.
Now, if you agree that it is a political question, if we do not say anything, when we take a position saying, this is our position, Mr. President, we would like to disagree with you. We would like to know what are the fundamental reasons why this change of position is taken. And we have the duty also to make sure that we don't shirk from our responsibility and tell the Filipino people we disagree with the President, and therefore now there is a constitutional issue that can now be brought to the Supreme Court of the Republic of the Philippines, Mr. President. Would you agree, Mr. To the minority floor leader?
Yes, Mr. President. In fact, 3 years ago, we had a resolution signed by 14 senators expressing the sense of the Senate that any abrogation of the treaty must carry the concurrence of the Senate. Unfortunately, that resolution was not acted upon. So there were, in the subsequent action of the Senate on each specific treaty, there was a clause which imposed this condition that any withdrawal from the treaty should have the concurrence of the Senate. In fact, this is a stronger provision than the sense of the Senate because it is part of the ratification or the concurrence itself, Mr. President.
And really, first-year law, when somebody is given a right to approve something, when the facts change, if there is an implied right, and it doesn't have to be expressed, that the same people can obviously take a position, express its sense, and even question it to the Supreme Court, especially if it comes out with a positive response, such as a resolution saying that, indicating our position on the matter.
We agree, sir.
Sir?
We agree.
Okay, sir. In that case, Mr. President, the debate really is leading towards that position because we don't want to go into lock horns with the President because we agree you are the helmsman. I don't believe you are the oarsman, but we sail the same ship of state, Mr. President. And therefore, we must have a say, especially on this important matter. Thank you, Mr. President.
Thank you.
Majority Leader.
Yes, Mr. President.
Senator Marcos, Senator Amy Marcos, recognized.
Yes. I would like to know if a vote was recorded on my part.
Yes. From yesterday's on the resolution 312.
Yes, I would like for
Yes,
that vote.
because there was a motion to adopt resolution 312. That means a vote, obviously.